Okay, so Hybe, Music, and Adore. I hope that you are realizing I am trying very best to not pronounce or say the name of the woman, Mama Roach, and the girls, because I've already explained to you how powerful um, our own words are, what we post and what we say. So until it is resolved, I don't want to add to their brand power. Okay. So that's why I am always skewing it towards Hybe and Adore, because those are the brands that I would want to push, not the other brands. So, as you know, the five girls, actually old shorts, well, they terminated their contract. And one of the oddest things that happened is that they said that they are not going to file for an injunction. They're not going to legally terminate their contract in their in their head, because HYBE or Adore violated the terms of the contract, then it allows them to automatically terminate the contract. So they're not planning on filing a case, they're just terminating it. So it's a one sided termination, but because they believe that HYBE or Adore violated the contract, then the termination is valid. Verbally terminating a contract, sure. Okay, so why? Because for them, there is a clear basis. Is it valid? No. Because even if there is a clear basis for a contract termination, you still have to go through a legal proceeding. Any kind of legal contract will have to go through a legal termination. There is no automatic thing in this world yet. There is nothing yet that automatically terminates a contract. There may be in the future, if they start using the blockchain, but it is not yet legally terminated. So think about it. Marriage contract, for example, is the clearest example. If your partner starts beating you up or starts disrespecting you, that is a clear basis of a divorce or an annulment. No questions asked, especially if you can prove that your partner is beating you up, um, s- spending your money away without consulting you, abusing you in some way or another. Clear basis for an annulment or a divorce. But you still can say, "Oh, I'm divorced." Right? You can't do that. So you still need to go to the court and tell the court, "Hey, this guy or this girl or whoever, my partner is beating me up. You're gonna have to terminate our marriage contract." Same thing is true here. Even if, let us just assume for the sake of this argument, even if Hybe and Adore actually breach their contract, they're still going to have to go to the court and tell the court, well, they breached the contract, please nullify it. Now, does this allow old shorts? And this is one of the questions that were raised. Maybe they're doing this because by doing this, they are terminating the contract and they can actually proceed to work and just consistently work as new jeans without having to wait for a legal decision. Because if they go to the court and file for an injunction, they're going to have to wait for the result of the injunction to do anything. That is not true. Even if the case is pending, they can still fulfill their obligations and continue to work while the case is being heard. The court cannot stop somebody from making a living. I don't know if you know that, but the court, it is protected by the law. They can't stop you from making a living. So for example, that's why a non-compete can actually be questioned. It can be questioned. A non-compete can be questioned in some cases, because if that is my, for example, if my skill is in programming and I signed a non-compete, you fired me, and or I resigned or whatever, and I find another company of the same nature that is and I start working as a programmer. You can't stop me from doing that automatically, because that is my skill and I need my skill to make a living. The same thing is true with a contract like this. The court will not stop them from working, especially if the obligations that they're going to be fulfilling will still be under Adore and Hype. So that is not true that they will have to wait for the legal decision before they actually can work if they file for an injunction. Now, the other question is, do they want HYBE to file a case so that the burden of proof is on HYBE's side? This is a solid argument. This may be because I heard some people said that they actually consulted a lawyer before they did this. So that is true that whoever file a case will have to actually, they have the burden of proof. So they may be, what they're trying to do is forcing HYBE to file a case first so that it is HYBE's burden of proof. However, no law firm is going to advise them to do that because if they lose, they are going to pay more because of what they have done. They are already breaching the contract with what they are doing. That press conference is a breach of contract already. The mere fact that they don't want to meet with the CEO, that's a breach of contract already. So all of these things that they are doing, they're already breaching the contract. So no law firm worth their salt is actually going to advise them to do it this way. So probably in their head, whoever files the case will have a burden of proof, probably, but no law firm worth their salt will ever advise them to do that. One thing we do need to remember is that during the conference, they very, very clearly distanced themselves from Mama Roach. So they made it sound as if this is just their decision. Mama Roach has nothing to do with it. In fact, they said when they asked, when the reporter asked, how are you going to fulfill your obligations? Like, what do you mean when you said freely work? Because that's something that they said they want to work freely, and they said that that means they will have the freedom to work with whoever they want to work with. And if Mama Roach actually wants to work with them, wants to continue working with them, then they would love that. So they are making it sound. And then later on, another one of them said that they have not spoken, that she has not spoken with Mama Roach. So that is very, very clearly an effort for them to make it clear that Mama Roach has nothing to do with what they are doing, that this is just their decision. So it feels like they are the ones that are actually protecting Mama Roach, not the other way around. And it's just so crazy to think that all of this started with HYBE auditing Adore when Mama Roach was the CEO and getting caught trying to take over Adore. Remember that the court did not deny the fact that Mama Roach are doing things that could weaken the hold of HYBE over Adore. They said it in the decision. They said Mama Roach may have actually done things to weaken the hold of HYBE over Adore, but she did not damage Adore. And she's the CEO of Adore. In that case, you can't use that as a basis to fire her from being a CEO of Adore. So very, very clearly, the court said, yep, she was actually trying to weaken the hold of HYBE on Adore. That's clear. Um, all of this started with that, and somehow, this is her brilliance. Somehow, it became New Jeans versus HYBE and Adore instead of Mama Roach versus HYBE and Adore. Don't you think that's something amazing? Now, one thing that we do need to remember is that HYBE actually saw this coming. Let's not, I know that a lot of people like insulting HYBE, like they're stupid or whatever. Make no mistake, they know that this is coming. We all saw it coming. I mean, if you're a member of my Patreon community, you know that we're already assuming this is going to come. It's just a matter of time that they were going to file for a termination, that they would leave Adore, and they're going to do everything and anything that they can to continue working with me, with Mama Roach. So if we can see it, so can HYBE, right? If we can see and actually predict their next move, so can HYBE. So make no mistake, they know that this was going to come, and they have very well prepared for this. In the last financial report, they made it a point to emphasize the fact that even without New Jeans, the company value is fine. Okay, everything that they have done since then have been to show that they are all making an effort to respond to New Jeans' request so that in the legal proceeding, they can present everything that they have done. In other words, the letters that they have published, the responses that they have made, them continuing to make an effort to prepare for next year's tour and the next album, trying to secure new endorsements for the company. All of this because they want to make sure that when they go to court, they can clearly prove that they have done their part and then some. That all that they have done everything that they can to make new genes feel and know that their interest is being protected. So this, they are not, when you read those letters being written by the CEO, by the CEO of HYBE, it's not them begging to stay, to make new genes stay. This is them covering their asses, so that, especially in a legal proceeding, this is them making sure that in the eyes of the law, they have done their part and then some. So people that are saying that, oh, Hive is not like, they're desperate to keep new genes. They probably want, of course they want their to keep their IP. That is a source of income, and they want to keep it. But more than that, this is them covering their ass. So remember, when people are talking about, oh, Hive doesn't know what they're doing, no, they're 100 steps ahead of everybody else. All of these letters, all of these nicely written letters, motherly love, making new genes feel that they are very, very important, and emphasizing the value of new genes, it is because they want to make sure that when they go to court, they can tell the judge, hey, we have done everything that we could and then some. We have emphasized the importance of their brand. We have made it clear to everybody else that we are protecting and appreciating and recognizing the value of their IP. We have all of these plans. We have written them letters. We have tried to call them. It's not because they are desperate, it's because they just want to make sure that in the eyes of the law, they are doing their part. Okay, Hybe is playing, according to Janine, Hybe is playing the long game. It seemed that they were reading the answers off the iPad, so someone could have been typing the answers for them on the Messenger app. It is a possibility. It was, I think it was it was rushed. They weren't, I don't know if you guys know this, but when there is a press conference of any type, especially if it is a celebrity, there is a PR company that would prepare you, and a law firm that will prepare you. So what they do is a mock conference. So, and I do this a lot with my clients. I work in PR. So what we would do is a mock interview. So we would actually sit down, put them in front of the camera, and we will play reporters, and we are going to throw questions at them. And then they're going to answer. We're going to tell them, you're doing this wrong, you should answer it this way, and whatever. Okay, I'm going to tell you a very specific PR tip, a PR trick, and this is what we teach our many of our clients. If somebody asks you a question and you don't know the answer to, do you know how to answer? And you hear this a lot. I'm pretty sure you hear this a lot in many of the interviews. There's a trick. If somebody asks you a question and you do not know the question, what you say is, that is a very you hear this a lot. That's a very good question. Let's say, John Smith. Hi, that's a very good question, John Smith. Thank you for asking that question. Usually, there are two things when they say this, when they repeat when they say that, when they praise you for the question and thank you for the question. It could be two things. They are preparing to deflect your question, and they're actually thinking about your question, how to answer a question. Usually, a deflection will sound like, "Thank you for asking that question. That's important. Thank you for bringing it up. I appreciate you being here." And then they will say something else that will not answer the question. It happens so often. Okay, one important, the latest thing, the most prominent time, one of the times that it actually um that actually happened was Jerome Powell. I don't know if you know him, but he's the head of our central bank in the United States of America, and and he was asked, when was that? I think several that happened this year, but several months ago, and he was asked like, how do you determine how much money to print in the US? Because remember, we have overprint in the US dollar. And he was asked, how do you determine how much money to print? And he was like, this thing actually goes through so much, like a complicated process on how we're actually, for how we actually make a decision on that. But and then he started talking about how much money they have printed before. He didn't answer how they're determining how they're making a decision on how much money to print. He went and actually went through the every month and how much they have printed. Like that's not an answer to the question. You hear that a lot. It's called a deflection. So just try to notice. So that is one trick that a lot of PR people actually, we teach that to our clients. We don't know how to the answer to the question, deflect. So and then the other thing is like, if you want to think about the answer first, like you're trying to process your thoughts, usually you'll hear them say that, thank you very much, John Smith, thank you for that question, I appreciate you being here, and I think it's very important for everybody to know. Now this is the thing. So then once in that time frame, you should have been able to think about the answer. um, the other thing is that it always goes back to you. Anyway, I'm giving away too much on PR. All right. Are they deliberately feigning ignorance of the law when there are lawyers behind them? Are they deliberately? I don't know. I can't answer what their intentions are. Um, there is a possibility that they are deliberately feigning ignorance. That's a possibility. Um, I wouldn't put it past them, and I wouldn't put it past Mama Roach. I do think, though, that this is not something that the lawyers will advise. If the law firm or the lawyer is worth their salt, this is not an advice that they will give, because a lawyer would know that the ignorance of the law is not an excuse. Um, the age of one of the members could be an excuse because she's a minor, but ignorance of the law is not an excuse. So there are four members who are adults. You can you can't do that now. Though, and I said this to, I think it was the Bio Explorer who asked, or somebody on Patreon asked, like, um what, it was an intelligent question. Anyway, my response was, the the major thing, the reason we are all struggling to understand them and why they're doing it the way that they're doing it, is the fact that we are all logical, right? That you guys are, you understand the law, you guys understand the law, you understand it, and you understand the consequences of the action, because you're logical enough to think of what could happen as a result of what they're doing. The one thing that we are ignoring is the fact that they are not logical. so so you're asking a logical question and you're expecting a logical answer, but you're not talking to a logical person. So it's like talking to, you know, I don't want to say it, but you're talking to somebody who has no capacity to answer your question. So it will never make sense to you because you're a logical, intelligent person. That is not who you're talking with. They are confused. They have been brainwashed. They only know one thing. And so don't expect for them to understand everything else, because they are so hyper focused on something and they have been manipulated to think this way.